For those of you who don't know me, my name is Bruce MacFarlane. I'm the CEO of BDC Partners. I'm also a director in BDC Law and a few other of our investment businesses. Today's session is on, as I just mentioned, managing risk and protecting your business. So probably not the sexiest topic we've done for the year, Jane and Richard, but law and insurance. But it is a very worthwhile topic that everybody needs to know how to protect their business. So go through. So we're going to get some great insights today. So as I mentioned, Jane is the managing director of the law firm, so she'll be presenting today, and Richard is managing partnerships at Benjamin Insurance. So we're going to get a legal and an insurance perspective on all the things we're doing today. But as I also mentioned, we'd love to hear from some of the franchisors and other advisors on the call to get your take on some of the topics we're talking about. Before we kick off on the topic, just a little bit of background about BDC. So we've got what we call the BDC Collective. So there's a number of BDC businesses. So we've got a law firm, a property business, talent acquisition, business mentoring, as well as franchise recruitment as part of the BDC businesses. And we work really closely with the collective businesses. So Associated Projects provide shop fitting, Hatch is a lead generation platform, Gap Maps is location intelligence, Fordham's is accounting and corporate advisory firm. We've mentioned Benjamin and Little Giant is a finance business. So part of our world, we work with people that share our values, and these are the businesses that we work really closely with, and they provide their input and participate in our webinars, as Richard is today. As I mentioned, we'd love to hear your feedback. So if you do want to just ask a question, I'll see those, and we can do that. If you want to put your hand up and just or just sing out, we'd love to hear from you as well. The topics for today. So when Richard and Jane and I were chatting about it, there's lots of topics we can talk about where there's risks and a high number of risks. And so today, it's not specifically a franchising one. We didn't think we needed to go through the franchise agreement and risks in franchising. It was more a general discussion around particular risks in businesses. So the first area we're looking at is shareholder disputes and partnership disputes. And so, a number of people on the call are running businesses or owners in businesses, and they have partners in their business. So we're going to talk about that. Cybersecurity. So obviously something that's in the papers every day is people that are getting hacked in. And so what does that mean for your business? Obviously that flows through into a franchising context as well, as it may be a franchisee. Staff. So also disputes is a big issue that we need to manage. And so from a legal point of view, we'll just touch on how you can protect yourselves from workplace disputes, and also from an insurance point of view. And then the last area we're going to talk about is product liability. So 4 key areas. I'm sure there are others that we could go into, and happy to take questions on others. I'm going to stop sharing now, and we'll come back to the screen later because we are, there we go, doing it in a Q&A style. So there's not going to be 100, it's not death by PowerPoint today. But Jane, the first question on the shareholder and partnership matters is, if you do have a shareholders agreement or a partnership agreement, what sort of provisions should you put in there to make sure that you help with the dispute process and to minimise disputes?
Before I answer the question, just generally, it boggles my mind how many businesses where there's more than one partner, whether it's a company or partnership of individuals or companies, don't actually have an agreement. So to start with, you need to have one. So shareholders agreement or partnership agreement. But in terms of what it covers, when people are all happy and get into business, is the time to actually sit down and nut out what happens if anything happens later. So the shareholders agreement should outline what each party's roles are, roles and responsibilities. It should outline who's got voting rights and in which circumstances. It should talk about disputes, and if a dispute happens, what's the resolution process, and should actually provide for a proper process for resolution if there is a dispute, especially when there's 2 parties. And, 2 parties do tend to deadlock at some point. So there needs to be a provision of what happens if there is a deadlock. If any party is to be more involved than the other party and is to be paid a salary, how does that work? And how does that get reviewed? annually, otherwise by unanimous approval, etc. Also, and we're going to touch upon that probably just in the next question, but what happens if other unfortunate events occur, like divorce, separation, death, permanent disability, etc. As much as you don't want to think about morbid things at the start, you should, because then it ends up being a big mess at the end. And also, a lot of good shareholder agreements that I've seen actually outline for the business and the company or the partnership what insurances they do need to take out to protect their business. So that's the main sort of areas that I think need to be covered. And then obviously meetings and other things is just more procedural stuff.
Before we go to you, Richard, just from the franchisors in the room and the virtual room, if a franchisee has a partnership or two shareholders, do you look at the shareholders agreement? Is that something, so Will or Jason or Nana, is that something that is part of your process to look at whether or not they have a shareholders agreement, and then what does it actually say? Yeah, Anna, you have a look at it. Yeah, Jason, in your roles.
Yeah, 100%. Yeah, and previously with Bakers and even with Explore and Develop now we do.
Yeah. So it's really important, I think. So this is obviously at a franchisor level. If you've got business partners, I'm not sure, Anna, if Amber and Matt have a shareholders agreement between the two of them, but when it's husband and wife. But if there's business partners in it, but I think at a franchisee level. But Richard, what about you from an insurance point of view?
Yeah, no, thanks. And good morning, everyone. I guess I just want to quickly, the risk side of me is this is just general information. It doesn't take into account your specific circumstances and impact and so forth. So obviously, before you undertake anything from an insurance perspective, you want to speak to somebody that can take all of those considerations into account. I guess where we're talking to go back to topic, where we're talking about minimising disputes, there is no insurance policy that will minimise disputes, but there is protection available, particularly where there may be disputes between shareholders. We're not talking partners, but specifically shareholders, and that's management liability as a policy. That policy does provide a lot of protection and protects directors and shareholders of businesses that may be sued as a consequence of actions by the company. And it's also there to protect the wealth. Now, we'll talk about management liability in a little bit more detail later on under other circumstances, but when specifically we're looking at disputes amongst shareholders and partners, for partners of a business in disputes, there is no protection afforded, but for shareholders, absolutely there's provisions within management liability to be able to provide some protection from that perspective. Again, the policy needs to be structured around the business itself, the nature of the shareholder agreement and so forth, but there's some obviously a lot of due diligence that needs to take place, but there is that provision available, absolutely.
So it's the management liability policy is taken out by the shareholders or by the company?
It's taken out by the business on behalf of, but there is many on the call today may be familiar with the old directors and officers policy, which used to be a standalone policy that a lot of people take. That is now really as a standalone policy. It's really applicable now for publicly listed companies and those that are earning $500 million in revenue and so forth. Within management liability policy, that provision exists specifically for businesses that certainly would be franchise businesses. So there is some protection afforded within there, but again, it needs to be structured specifically to the business in question, and obviously the risk appetite and the circumstances of the franchise business in question.
Cool. So shareholders agreements are one of those documents, as Jane mentioned, that often they should be done at the start of the relationship, and they may not even come out of the cupboard again until the end. So either someone wants to leave the business or an event happens. So Jane, what sort of mechanisms are in place that you recommend to put in place where there's either a separation or a death or some tragic event, which is obviously a tragic life event, but it has implications on the business?
Yep. I'll probably address death first, death or permanent disability. Most shareholders agreements that I've seen that deal with death have a mechanism by which should a shareholder, if it's a person, die, obviously all of their assets go to their estate. But there can be a mechanism by which the other shareholders can compulsory acquire the shares of the person that died. And there's a formula of calculating the value, obviously based on market value or a valuation criteria of some sort, which could be predetermined. And it's, talk to the accountant to get that formula correct. But if you have that in place, and often, two partners get in business together, if one dies, the other one doesn't necessarily want to work with the wife or the children of the partner that's passed away. So probably the compulsory sale is the best mechanism for death. In terms of separation and divorce, could be the same. So there's a compulsory acquisition of some sort of the interest by the other shareholders, or at least it needs to be addressed into how those shares are managed. Because what I've seen happen is obviously shares in a business are an asset. And when there's a divorce proceeding, it's one of the assets of the marriage that gets split up. And often businesses get hindered by the fact that it's part of the family court proceeding, decisions can't be made, business can't run properly, etc. So there needs to be a mechanism similar to death that deals with it. I note that for the franchising people on the call, obviously a lot of franchise agreements that I've seen and or drafted do deal with separation and divorce of the partners within the franchisee and what happens in that scenario. I know, for example, bakers have a big separation clause in the agreement that deals with what needs to happen with the franchise business should there be a separation or divorce.
Yeah,
It
can be quite. I know we've been involved in situations where the partner, a couple, are involved in the business, and the one that's actually not working in the business ends up with the business, and this shares through the court, and it's just a nightmare because all of a sudden they own a third or a half of a business. So yeah, that was at a franchisor level, but it's also happened at franchisee level. So yeah, so Greg, for franchisees, that's this can happen for them. So putting it in from the franchisor's point of view, ensuring that the shareholders agreement between the partners in the franchisee business have clauses in relation to this, that the person who's actually actively involved in the business is going to end up with it, or else the other partner can buy them out. The issue, and we'll talk.
There's an alternative. Sorry, Bruce, I'll interrupt. There's an alternative for franchisors, and the alternative is that the business gets put on the market and needs to be sold within 3 to 6 months. That's one of the things I've seen done in franchise agreements. And if it's not sold within 3 to 6 months, there's a valuation process where the franchisor can take it off their hands.
Yeah, so it's a little bit about who's actually running the business and the key individuals behind it, and ensuring that the business is still successful because the people that are actually have the skills to run it are still running it.
Yeah,
not because the family court decided that someone else has a better entitlement to the asset itself. Richard, from an insurance point of view, I know it's not something that you guys do your business, but like looking after death and disability and other policies.
Well, yes, there's death and disability, but there's certainly also protections in relation to separation or death of shareholders. Again, a lot of that provision comes through key man insurance, which again, as a general business insurance broker, isn't something that we necessarily provide as protection, but is a lot of wealth managers or insurers that's focused on those personal insurances, income protection, death and disability, and so forth. Will have access to it and be able to put a key man provision in place. That's a really good, particularly if you've lost some skills within the business, the ability to be able to then have protection that can provide an income stream to actually go and recruit somebody else into the business to be able to take over that role and to bring some skill sets and expertise that you're needing. particularly in the loss of a separation of a key person within the business. Hence, it's called key man insurance. That said, again, there's a number of different provisions within management liability to support a business, and there is a component within management liability that can provide some cover in a situation where shareholder has passed away in death during their business activities. There are some variances around that, but again, there is certainly some cover afforded and available in a situation where shareholder might pass away in their work duties. And again, it's something that encourage business owners and shareholders to explore that conversation with their general insurance business broker, if that's something that they want to explore, that additional layer of protection outside of what Jane has mentioned, that is available to them.
Greg, I think we've answered your question in terms of what it typically looks like. Is there any other questions on shareholders agreements? We're just going to move. We'll have more question time at the end, but we're just moving through the different topics. So to cybersecurity next.
Hot topic at the moment.
Yeah.
Had a massive data breach.
So I guess Jane, the failure to implement cybersecurity measures can expose a business in lots of different ways. We've all heard the terrible stories where people have lost lots of assets, and I guess cybersecurity can come in lots of ways. So what sort of things do you recommend?
Yeah, well, in terms of loss, when there's cybersecurity incidents, it's not just financial loss. At times, it's loss of reputation. It's disruption to operation, depending on what it is. For example, if it's ransomware and you can't access any of your technology, there's obviously legal consequences because people can sue you if there's data leak, other things that happen, and also supply chain risks for deliveries and other, businesses that have products that they sell. In terms of what they can do, obviously every business needs to have proper policies of how cybersecurity is actually done in the business, what it covers, and it needs to consider all the possible risks of cybersecurity, like your phishing attacks, your ransomware, your data privacy breach, generally lack of security resources, and it needs to be addressed and have some sort of protections in place, including, for example, obviously really good antiviruses and, those kind of things, which don't always protect. And we've seen, as I said, Qantas had their Manila branch tricked into providing access. So, and there's a lot of data that has been leaked on the dark web, which we'll still see what the consequences are because it's only happened. So, so there needs to be sort of training. Employees need to be trained in terms of what the policies and procedures are in relation to cyber. For example, that employees cannot access certain websites, certain things on their work computer. That's one of them, and can't do other things than, work accepted websites and work accepted programs. They can't download all sorts of apps on their computers and their devices that they've got. Multi-factor authentication is a big one. And we can see that most of the big companies do implement, if you are trying to log in, that there is some form of second check with the multi-factor authentication, whether it's another email, whether it's on your phone, whether it's an authenticator app, etc. And obviously regular backups, because if your server gets, and when I say backups not necessarily onto the server, because server can be accessed in these kind of attacks, but is there a secondary type of backup that you can do for all the information that you've got? So that's generally the realm of things you could do.
Yeah, so Jane, this, I guess, and to touch on Greg's question, there's two parts to it. There's obviously protecting your own data and your data of your and your employees and stuff, and then there's the client data. So particularly franchisees are collecting clients' data depending on the business. Obviously, some of them that are more medical related are collecting more sensitive stuff compared to others which are whether or not they're buying a book or not, it's probably not as sensitive, but it's still their phone and their email address and things like that. So it's important both ways, I guess, from the franchisor's point of view, to ensure that they're protecting their own data and they've got those things in place, but also that their franchisees are also doing the right thing as well. So is that something that you talk to franchisors about, ensuring, and it's even random testing of franchisees or doing insurance, making sure that their franchisees have got all the right, are following the policies and complying?
Some franchisors that I deal with actually have specific insurance policies in place that franchisees have to take up, one of which is cyber, but they also have specific policies and procedures for franchisees to follow. And I've seen franchisors breach and terminate franchisees for not following the specific cyber procedures. So, yeah.
So it's ensuring, that
it's important. You've got to protect
the franchise agreement, but also what's in place to a policy and within the manuals, and ensuring that the franchisees are complying with that. And Richard, from an insurance point of view, what sort of cybersecurity policies are in place to protect?
I think Greg also asked the question on insurance.
Oh yeah, we'll go to you, Richard, because I think this ties into you.
So I guess thanks. So I guess there's two scenarios. There's cybersecurity and then there's cyber insurance. They're two different things. So there are cybersecurity will be policies and procedures around managing data and multi-factor authentication and your IT environment and things that you can do from a protection perspective. The cyber insurance is if something goes wrong, then what protection do we have in relation to that? And that's where, again, the insurance will come in. And it's interesting from an insurance perspective that cyber incidents and data breaches are classified and viewed and protected in exactly the same way. And a lot of people don't realize that when we're talking about particularly client protection and sensitive protection, a data breach from a regulatory perspective could potentially be something as simple as losing one of these. Or leaving it in a taxi, or whatever the case might be, particularly if that has access to sensitive information, or if you can get onto servers and other areas where you store that. So it could be a phone, it could be a laptop, it could be an iPad, anyway from that perspective. So it's really about, from an insurance perspective, it's what protection is afforded in relation to if something goes wrong. And Jane's mentioned a number of things. It's not just about what if we're hacked, or what if there is a ransom scenario, and how do we cover that? There's reputational risk. There's the ability to be able to go, how did this, and do the due diligence where you can get a SWAT team that can come in and look at your IT environment and go, how did they get access? Where did they get access? Potentially, how long were they monitoring our IT environment and we had no visibility of that? And then what do we do as a consequence? So how do we go out and maybe communicate with our customers? How do we look at our reputational risk in the marketplace? Let alone the possibility of, what happens if there's regulatory fines and penalties if we've been seen to be having not necessarily done the right thing. So there is a number of different protections that are available through cyber insurance. It doesn't need to be expensive, but you do want it structured specifically to the business in question, and insurers will want to get information around what protections do you have in place, what policies are you undertaking. So all of that information will be things that the insurers will be interested in. I guess it's like with anything else, insurance or otherwise related, you get what you pay for, but there are definitely years of protection available, but certainly, at the higher end. And as I said, it doesn't need to be, overly expensive, because, costs associated with cyber insurance have decreased over the last years. where you can get, all the protection afforded to you for a team to come in and mop it up, to be able to get, professional support regarding PR, crisis management, have your IT environment swapped out as is appropriate, and a lot of other protections. Again, as business owners, you make the determination as to what level of cover you want, specific for your business and what's in line with your risk appetite. But it certainly is available to give you that protection for financial loss and other elements that will impact your business as well.
So, Richard, just Greg's question is, it's as there's more issues with, flood. I think Greg say floods in Queensland, and it's hard to insure your house for floods now because of that. So, if there's more and more, data privacy breaches and then claims against it, you said that it's coming down in price, which is great for businesses. But if there's more instances of claims, I assume that just means the price goes up.
Well, you've also got to look at the fact that more and more businesses are insuring themselves, and so therefore there is a bigger pool that the insurers of premiums that the insurers can apply in relation to the claims or the payouts that they will be making. So it is a bit of a balancing act from that perspective. But yes, the reality, from a risk perspective, is that greater than 50% of businesses in Australia will be targeted. It doesn't necessarily mean that, they will have a cyber incident, but they may certainly be targeted. And that's one thing that we're seeing. So again, the encouragement is certainly look at taking out the appropriate insurances. And there are plenty of instances, as Jane said, where somebody may receive something as simple as an email that looks like it's come from their CEO or CFO saying, there's a payment due, it's imminent, can you just, slight change in details, can you pay it now, get it done? And an employee might look at that email and go, it looks genuine, the wording is right, or it's just that I'm telling you there's a change in bank account details, I haven't told you as yet, you're getting it from me, go and do that. And historically, if you didn't have insurance, that money would be gone. But there is, again, provisions within cyber insurance that, a lot of that money can be recouped and can be recovered, as well as the other protections that can be afforded. As we said, things that may impact the business, from a financial perspective around the cost of getting the appropriate PR support or crisis management, or what are the impact to your customers, what is the impact to your staff, suppliers, and so forth. That can look at providing some protections around that.
Can I just say another thing is a lot of businesses who have teams offshore, so in overseas in different countries, those teams are more likely to be phished and attacked by whoever's trying to get your data, whoever's trying to get money out of you, because obviously English is not their first language and they won't check as much as a lot of Australians would.
Yeah, and that's a really good point. And it doesn't, in any circumstances where you're engaging with third parties offshore, it's good to verify that they have the appropriate insurances in place around the scope of work that they're providing for your business, whether that be, offshoring, things that are specific to client information and so forth. So it could be, a bookkeeper or an accountant that's doing a lot of work over, engaging third parties offshore to do a lot of their back-end processes and so forth, but need that access to that information, or whoever, manufacturing, whatever the case is. If you're dealing with third parties overseas, it's good to, not just to ask the question, but ask for copies of those policies, and then have somebody locally vet those policies to make sure that they're actually fit for purpose, so you don't get any nasty surprises, unfortunately.
Have you had areas where there's been limitations on people's ability to claim under the policies? Have you seen that?
Again, you want visibility of that to make sure that they're structured right, so that, if you've got somebody doing some work offshore and then the flow on is to Australia, you want to be able to make sure that their policies can be called on. Particularly around recovery, because what may very well happen is that you may make a claim using your local insurer, who will then go and seek to address costs from an insurance company offshore, which is what we refer to as recovery. So party A will then go and look to seek to reimburse costs associated from another party, but you want to make sure that they're structured right, they're legitimate insurers, and they have the right to actually operate in those jurisdictions as well. So there's a lot of little things and safety nets that you want to double check. You don't want to just take it on face value as somebody says, well, I have a certificate of currency and this proves it. Certificate of currency doesn't really give you any information around the specifics of the policy. Who's the insurer? Who's the underwriter? Are they, legally obliged or able to operate in a particular country? The level of detail that you need for scrutiny. You really want access to the policies, and you want to get visibility of those policies to be able to do your own due diligence as well.
And any of the franchisors, is this something that you're looking at the policies of the franchisees for cyber, or you're taking out a policy on behalf of them? Is that what's on behalf? Will, what are you doing?
I don't believe we currently have any policy around cyber.
Yeah. Jason, or who else is there? Steve? Anyone else? Marina, what are you doing in your business?
Yeah, we've got pretty robust policies, especially around authentication, and that's something that things are always evolving. But yeah, I'm very comfortable with what's being said there, and we're aligning with that.
Yeah. And is that at franchisor level, or do you check the franchisees, and even or in your previous role?
So you've touched on something, franchisor level, and I think the next evolution of conversation, though we've got policies for franchisees, is probably getting a little bit closer to what they're actually doing. And within the sector I'm in now, they're using a lot of external apps for early education, so Owner as an example. So it's getting a little bit closer to understanding their frameworks for those specific apps if there's a breach. So it's less about the onus being on the franchisee, more about, okay, we've got 5 or 6 external apps we're using. We're probably going to get a little bit closer to the mitigation, the prevention, and what occurs within those apps, less about probably our action.
Yeah, and that's a really good point, because when you're looking at that IT environment, you want to be able to look at the protection afforded up and down that supply chain, whether it be from franchisor to franchisee and beyond as well, to make sure that those policies are structured to be able to make sure that all parties have the relevant protection afforded to them. Particularly franchisees are using franchisor systems. Granted, the franchisor might have some insurance afforded to them, but we're also encouraging franchisees to take that out, because if they're reliant on a system that the franchisor has, and that system goes down, there is no guarantee that the franchisee will be protected around loss of income and financial impact to them as well. So you want to look at it from all parties' perspectives.
Yeah, cool. And a nurse next door, I'm sure that a lot of pretty important information that's collected at both franchisor and franchisee level. Are you managing it at head office?
Yeah, so we've got franchisor policy, and we actually have franchisee policies in place as well. And then we've got a lot of internal policies and procedures that franchise partners actually have to follow, and caregivers. We've just rolled out, mobile phones is probably a massive part of our business with our caregivers that has sensitive data on it if they're accessed. So making sure that everyone actually has passcodes and everything locked on their phones, which was a gap that we found when we started delving into cybersecurity.
You got a lot of people on the road and lots of information, so pretty important. I might move on from cyber. I know we could probably do a whole hour on cyber. There's lots of stuff to talk about and lots of examples, good and bad, but maybe workplace disputes. So Jane, what's the importance of providing training in workplace policies, to reduce risks for claims around unfair dismissal or bullying or discrimination?
Well, to start with, every business needs to have policies in relation to bullying, harassment, unfair dismissal, etc. Because if there is a claim by an employee and you don't have any policies and procedures, or they lack in a lot of information that they should contain, the employee already has an upper hand. In a lot of cases with Fair Work Australia, it gives them just that much more leg to stand on, to be honest, if you don't have any policies and procedures. Another thing is what all employers should have is a log of any incidents and proper incident reporting. Because if there is an incident that will obviously flow into a work cover claim, there needs to be proper procedure of how it's reported, who it's reported to, what the actual report looks like, what information it contains. The more elaborate the report is and the more information in it, then it's less issues will be once there is a claim potentially lodged with work cover.
So that's a work cover claim. Does that apply for bullying and discrimination and things like that as well?
Bullying and discrimination is a bit different. Bullying and discrimination is fair work and, claims. To be honest, you can't stop an employee from making a claim, and there's a lot of there's a lot of legitimate claims by employees, but I've seen a lot of bogus claims for a payout from employees in terms of bullying, harassment, unfair dismissal. Unfair dismissal obviously is one of the bigger ones when someone gets terminated. So in terms of terminating someone, you must have proper procedures of warnings, performance, whatever it is that you are getting them terminated on needs to have a process of how you get there, and that you followed all the proper warning letters. Once again, does not exclude the employee going and making a claim, but you actually can defend. And I'm not an employment lawyer, but I've helped a couple of our clients with some of their fair work disputes, and we've won a number of them based on the fact that the employer had proper documentation, proper procedures, proper warning letters, proper, even in employment contracts, outline of what's expected, minimum criteria, et cetera, especially as, we're not talking about minimum wage stuff, but you're talking about sort of the middle management or, somewhere in between that middle management and entry employee, which is often where the claims come from.
And Richard, what does the business do to protect themselves is about the loss that they may suffer if those claims are successful?
Yeah. Again, I'll go back to management liability as a policy. So it's a really interesting one. That's a policy that not a lot of, or there are a number of employers that don't even know that this policy exists, and the protection afforded to them as business owners, and the protection afforded to officers, to shareholders, but also employees and the work in their day-to-day role. One of the major components of a management liability policy is the employee practices component, and that provides protection specifically for where there may be claims made because of discrimination, harassment, bullying, dismissal, and so forth. And especially where there may be a frivolous claim. So sometimes there may be a frivolous claim that may be somebody seeking $5,000 as an amount. But if you don't have the protection afforded through the appropriate insurance, it could be $20,000, $30,000 out of your own back pocket just to be able to go and deal with that frivolous claim, let alone if it's a legitimate claim based on what might have happened. So again, there is a component within management liability that will provide the protection. If there's a claim made, you engage your insurance broker and let the insurance company take that claim on and to manage that process either out or through to its conclusion. I'll give you an example of what some might consider to be a frivolous claim, but was actually a real life example. So there was a hairdresser in Melbourne, and they were looking to employ staff, female staff in particular, because they wanted that staff through their own hairstyles to represent the kinds of haircuts or styling that they could do for their customers. And there was a lady that came in for the interview, and she wore a headdress. It was asked if she wore the headdress always, and if it could be, if there were circumstances that she'd be happy not to wear it because of the reasons as discussed about becoming almost a human billboard for the kind of work that they did. She wasn't given the job, made a claim that she was discriminated against because of her religious status in relation to wearing a headdress, and took that business to court. It ended up being quite expensive in legal proceedings. Fortunately for this particular business, they had management liability, so that entire process was managed and all the associated costs were taken care of by their policy. All they had to do was cover the excess, which I think in this instance was about $1,500 based on that policy, but it ended up being thousands and thousands of dollars worth of court costs and so forth, which otherwise, if they didn't have that policy, would have had to be out of their own profit, out of the back pocket of the owner. So again, this is highly valuable insurance policy that we recommend to all employers who do have employees working for them to take that out, specifically structured for their business.
Well, I don't think we would get a job at that place either. We'd have to make a claim on behalf of people that are politically challenged, because I don't think it'd be a very good walking billboard for a hair salon.
They might make you wear a wig, Bruce.
Oh, that'd be all right. Yeah, we could.
Yeah.
I'm passing no comment on that whatsoever.
So, Jane, you mentioned the Fair Work Act. So, are there, consequences for business if they don't have the policies and procedures under the Fair Work Act?
Yep. So, well, there's a lot of consequences because obviously Fair Work can send an inspector and issue compliance notices, and there's other penalties under the Fair Work Act for obviously breaching the Fair Work Act. So my recommendation is to actually review your policies and procedures in relation to employment, and also in relation to bullying, harassment, etc. So the lawyers one, yes, Greg. Lawyers always win.
To answer your question, Marina, actually, the lady won that case. It was appealed, but she won the first case.
Cool.
The thing is, in court, quite often, this is what I see in employment. The court is more likely to side with the employee. So, and there's more onus on the employer to prove that they're actually right. So,
do we want any other ones on employment? Richard, do you have any other employment examples before we do product liability?
Well, there are so many. It's not so much about the example; it's more about the principle. If there is a claim, harassment, bullying, workplace relations, in any of those scenarios, a properly structured management liability policy will provide protection against all costs associated with managing that process, and will take some of the stress and the headache away from the business owner, whether that be the franchisor or the franchisee who may have employees. And it's a policy that we consider absolutely best in class for all employers to look at taking that out. There's about half a dozen different components. You may not want to take all of those components, but as spoken about this morning, certainly the directors and officers component around the protection for directors, shareholders, employees that may in their day-to-day course of their work, and certainly that employment practices component. They're the two that we think are absolutely best in class for business owners to take out.
Yeah.
Cool. Any other questions on employment? We might move to the product liability piece. So Jane, what gives rise to a product liability claim? When does this come about?
Well, generally, obviously, the rise of the claim is if a product is deemed defective, unsafe, or unfit for the intended purpose, which then potentially leads to harm or injury to consumer or their property. And often product liability claims come under sort of your breach of contracts, goods being unacceptable quality, non-compliance of a business with express warranties in relation to those products, and as I mentioned, injury or property damaged as a result of usage of the product. So that's what usually gives rise to claims.
Okay. And then how does strict liability operate in relation to these claims, and kind of what defenses do people have when there's a product liability issue?
Generally, product liability cases are subject to strict liability, which basically means that when someone's making a claim, they just have to prove that the product is defective, they've suffered injury, and there's a link between them suffering the injury or damage and the actual product. And in terms of defenses, there's three types of defects that could be claimed as well. So there's your design defect, there's a manufacturing defect, and there's warning and instructions defect when there's not enough warnings. For example, a lot of kids' toys, etc., have a lot of warnings on, can't use under 5 years old, can't use under 12 months, whatever. And if those warnings are missing, potentially consumers who buy those products and use them, say, on a child that injures themselves as a result of using the toy or the product, they can make a claim for product liability. So that's, yeah. And in terms of defenses, you obviously have to try and prove that either there's no defect or there's no cause between the product that they've used and the damage or injury that they've suffered, which often, especially when it's the consumer products like toys, is sometimes hard to prove, especially if there's, as I said, missing labels, or there is a defect that can be easily proved. So,
okay. And Richard, what about from the insurance point of view? What should businesses do? I guess there's lots of products that are used in all sorts of, people on the call in all different
yes,
Yeah.
rather than just products that are being sold, but are being used
No,
providing service.
No, absolutely. I just want to go back one step if I can. Just again, if a business is a distributor of a product and they're bringing a product in from overseas, particularly if they're the exclusive agent bringing a product in, if there is a fault with their product, legally they are deemed to have the same obligations and exposures as if they were the manufacturer. So there is a heavier burden and onus on them if they're bringing a product in than what would otherwise be if potentially if they were just any number of people that might have access to a product that might be being brought into a country. So again, that's where your public and product liability insurance will be of value. But from a product recall perspective, I guess it's probably there is a number of different safety nets available. It's probably better for, as an example, to step you through a case study. So there was a third party had contracted someone to manufacture some products that had to meet a certain standard from a QA point of view and an Australian standard for it to be used in Australia. The manufacturer made an error. The stock was deemed to be non-compliant, and it was quarantined at a certain point. Now that could have left that business out of pocket extensively regarding having to make corrections and all sorts of scenarios. And even if it was a product that had been installed and implemented and then was found to be faulty, what are the circumstances about having to pull a product out and replace it, and reputational risk and all of those scenarios? All of those expenses can be covered under a product recall insurance policy. So that could include costs associated with notifications to relevant bodies and authorities around a faulty product, engaging and notifying customers, seizing product where necessary, engaging crisis management hotlines, notification or assistance as is appropriate, any PR support from a media or press perspective if that's required, communications, engagement, obviously the costs associated with stock returns, restocking, shipping, bringing product back in, all of those costs can be absolutely massive, but can be covered under a product recall insurance policy. So again, good to speak with an insurance broker who knows what's available and what can be provided around protection and a safety net for the business around a good product recall policy.
And this is, so just when you're talking earlier about the manufacturer or the distributor, so if a franchisor buys equipment from overseas and the equipment's faulty, does this something, and so the franchisee's got a claim against the franchisor because they're the exclusive distributor, is that something that the insurance would cover?
Yeah, absolutely. So you can, again, that's where you would take out product liability insurance that would provide that protection, recognizing you legally as effectively the default manufacturer, because if that's what you're doing. Yeah, it could be even a food item. It doesn't necessarily have to be a piece of equipment. It could be a food item. It could be shampoo if somebody's bringing in a particular type of shampoo for use that hair salons. It could be, any particular product from that perspective. But certainly if you are bringing a product in, if you're doing it exclusively for use within your business or your franchise network, if you're doing it as the franchisor, it's wise to have that level of protection.
There's also, I just wanted to mention, there's also a couple of other defenses potentially available. One's obviously the product misuse by the consumer. So for example, I don't know, if you take a hairdryer and use it in the bathtub and the hairdryer has all the warnings not to do that, then obviously you're misusing the product and you can't then go and make a claim against the manufacturer for, faulty hairdryer. And the same goes for altering the product. So if the product you bought, you then go and alter, you can't make a claim that it's defective once it's been altered.
So does the person making the claim have to be the consumer? It could be the franchisee against the franchisor if the product's defective as well.
Yeah. And again, going back to frivolous claims, which some may very well be, if you don't have the right insurance in place, even addressing a frivolous claim can be tens of thousands of dollars out of somebody's back pocket. Having this insurance in place to support your business, all those costs will be covered by your policy. It will just be the cost of the excess that you'll be liable for.
Yeah.
I'm conscious. Will, I'll come back to you on that about people that can do audits. I think Will had a question around that, and Richard and I, we might chat offline about that and come back about going through businesses. I know from an insurance point of view, you can look at it, Richard, but in terms of, I think what you're looking at there, Will, is a technology company that can come and see whether or not you're protected. Is that what you were getting at?
Yeah, I think just looking at all of our systems and seeing if there's any vulnerabilities there, what policies and procedures need to be in place to kind of protect ourselves. And then, of course, looking at the insurances in case something does go wrong.
Well, if you're looking for a third party, we can put you in touch with some people that are experts at that. And then obviously the relevant insurance over and above that. But again, we know a number of people that are really good at what they do in looking at policies and procedures and IT environment and so forth, specific to the exposure for your business.
Yeah. That'd be great.
Greg has a question.
Yeah, and so Greg's question, so I guess, I understand your question, Greg. So if you're a franchisor and you're requiring your franchisees to be using FranConnect or Salesforce or HubSpot, or there's a whole lot of different platforms, MindBody in fitness, and something goes wrong in that platform, obviously it's going to impact the franchisees. Or could be in some of those examples, it could be actually cybersecurity issues as well. But let's just assume it's malfunction and the booking system goes down or something. So the franchisee suffers loss, but it's a platform that the franchisor doesn't own; they're just using. Is that something that the policies can cover, or is that?
Absolutely. So that's again why that's a great example of what I was referring to, that where there are third-party platforms, if there is a financial loss because somebody's gone down, whether that be a Salesforce or as a third party, could be a payment gateway, whatever, and you as a business can't operate for a period of time, what are the implications to you from a revenue generating perspective, and implications around wages for staff and so on and so forth? That's absolutely where a cyber insurance policy is applicable for both franchisor and franchisee to protect them as individual businesses in those sorts of circumstances, and can cover lost wages and income and so forth in exactly the same way you may have a policy and your business, your place of business is flooded. And then there, you can't operate for a period of time, and then there's a period of time until you find another location, and you can have protection that gives you an income stream coming through to pay wages and your obligations and so forth. Exactly the same protection can be afforded from a cyber point of view, or from an IT environment perspective, if something goes down and impacts your business.
Cool. I'm just going to start the share. Is there any other final questions in the last couple of minutes that people?
I'll just make a quick comment because obviously we've spoken a lot about policies and procedures. So what I would recommend is after this call, go and review your policies and procedures, what they cover, what they don't cover, where you have gaps, and potentially need to add to your policies and procedures.
So whether or not they be your internal policies for your office, for HQ, headquarters, or for in the manuals, that you're requiring your franchisees to follow, and I guess linking that back into your franchise agreements as well to make sure that there's the appropriate links.
And just by extension, we're also very happy to do the same from an insurance perspective. We do a lot of insurance audits for business owners, franchisors and franchisees, where we're happy to look at the structure of the policies and the type of policies and the level of those policies specific for the risk of that business. And we're happy to provide, no obligation. This is what we've identified. Is it fit for purpose? And then go from there on in. Insurance brokers will have their own professional indemnity insurance as well, Greg.
So do lawyers.
Yes.
Last thing, I'm just going to, oops, that's not going to work. There we go. One thing, we're not running any more webinars for the rest of the year, but we will be running an in-person event as part of our Emerging Giants. So on the 13th of November in Melbourne, there will be a growth workshop, which we're going to go through on the theme of around business investment and business partnerships is a key part of that, around growth. But part of that is a pitch competition at the end of the day, where people can enter with a chance to gain an investment of up to $250,000. So BDC Investments has 4 franchise businesses that it currently part owns, and it's put up this $250,000 investment. So we've been open for about 2.5 weeks now. We've got about 10 people that are in the middle of the process. We'll get it to a group of 5 businesses that will pitch on the night for a chance. And so obviously you can see in the bottom there, Benjamin, Fordham's Associated Projects, Little Giant, and the BDC entities Law and Property are involved in a sponsorship partnership level. And Octo Media, if you're on the database for either Inside Retail or Inside Franchise Business, you've probably seen this come out through their databases as well. So for those of you franchisors that have got less than 25 units, you're looking for business partners, it would be great to apply. Or those, Greg, lots of franchisors that may be in that category, that it might be helpful to have not only a bit of cash as part of an investment, but also some expertise as part of that. So we've got Janine Ellis doing a coaching session, and Paul Roos as well. So Greg, I don't know if your business is going to, well, maybe. But we'd love to see it. But thank you very much for everyone that joined today.
Thanks, guys.
Thank you, Jane. Thank you, Richard. And we'll send out the recording of this by email later on. Thank you very much.
Thank you. Bye.
Thank you.